Hello everyone and welcome back to the channel. My name is Shoily Chakraborty and I'm working as a legal intern at LEXIS and Company. The topic of today's video is the infamous Mathura rape case and the subsequent anti-rape campaign following it. Mathura, a 16-year-old poor, orphan, illiterate tribal girl, was raped by two policemen within a police compound in Desaiganj, a small village in Chandrapur district of Maharashtra. She was brought to the police station in the evening of 26 March 1972 on a complaint filed by her own brother that she had eloped with her lover. At 10 p.m. at night, while her relatives were waiting outside after the interrogation, two policemen on duty, Tukaram and Garpat, took her to the toilet within the compound of the police station and raped her. When the relatives called out to her, she came out in a disoriented state with a torn sari and informed them that the policemen had raped her. Hearing the commotion, people gathered, and due to their pressure, a case of rape was registered. The medical report revealed that there were no marks of injury on her body and that the vagina admitted 2 fingers easily, which implied that she was habituated to sexual intercourse. Her age was stated as being between 14 and 16 years. The Sessions Judge Chandrapur on June 1, 1974, acquitted the policeman on the ground that since there were no marks of injury, Mathura must have consented. He labelled her a shocking liar with evidence whose evidence was filed with falsehood. The judge concluded that though sexual intercourse with the policeman was proved, there was a world of difference between sexual intercourse and rape. In appeal based on the same evidence, the Nagpur bench of the Bombay High Court reversed the judgment and convicted the accused to rigorous punishment, which included imprisonment for 5 years, and held that the passive or helpless surrender induced by threats or fear cannot be equated with free consent. However, in appeal, the Supreme Court in September 1978 reversed this judgment and upheld the judgment of the Sessions Court and acquitted the accused on the grounds that absence of injuries implies consent. The judgment shocked some law teachers who wrote an open letter to the Chief Justice of India, condemning it as they felt it would snuff out all hope of justice for millions of Mathuras across the country. The open letter was addressed to the Chief Justice of India in 1979. This letter gave birth to the anti-rape campaign in India and resulted in amendments to rape laws in 1983. An important aspect of the amendment was that custodial rape, that is rape in police custody, prisons, etc., was made into an aggravated form of sexual crime warranting severe punishment of a minimum of 10 years. The Supreme Court ruling had highlighted the fact that in a rape trial it is extremely difficult for a woman to prove that she did not consent beyond all reasonable doubt, as she was required under the criminal law. The major demand of the campaign was that the onus of proving regarding consent was shifted for cases of custodial rape. Since then, there has also been several changes in criminal procedures, police manuals, etc., which have given strict guidelines that women cannot be arrested at night and that they cannot be detained in police custody at night. Thank you. Please like, share and subscribe to the channel.